in case everybody wants to know. Okay, folks, thank you for that patience. We are recording today's Zoom meeting, and I'm also using a audio recorder as a backup. We're now on the recording for docket number CC-2023-OGR-01-001. It's 9:04 a.m. Tuesday, March 14th, 2023. We are at the Fruitland City Hall in Fruitland, Idaho. This is the time set for a hearing to address the scope of the factors I will consider when determining whether the terms and conditions of an integration order are just and reasonable as provided in Idaho Code 47-320 sub 1. For the spacing unit consisting of section 24, township 8 north, range 5 west, Boise Meridian, Fayette County, Idaho. My name is Mick Thomas, and I am the Oil and Gas Division Administrator presiding over and conducting the hearing pursuant to Idaho Code 47-328. Before I continue, I want to let everyone know that I have reviewed all the briefs and comments. I give equal weight to written and oral comments and arguments. There's some housekeeping. This hearing is in person with a virtual component via Zoom. This hearing is being recorded in Zoom as required by IDAPA 04-11-01-651. We also have a backup recording device recording the hearing. For those of you on Zoom, please mute your microphones until you are called on. Please speak loudly and clearly when it is your turn. If there is a disturbance, you will be reminded to mute your microphone. If the disturbance continues, you may be muted and or disconnected. For those appearing in person, it is important you identify yourself by stating your name for the record before you speak. If you are here as a representative, please indicate your own name as well as who you are representing. I may ask clarifying questions while you speak. When you come up, if you're in person, I moved the podium right here so folks on Zoom could maybe see. I think it looks like we've lost video again, so I'll bring that back. You could be speaking to someone other than me. Let's see if I can do that. Wow, there you go. As my January 31st, 2023 notice indicates, this hearing was noticed to address the scope of factors to determine just and reasonable terms. To be determined just and reasonable. The purpose of this hearing is not to address what terms are in fact just and reasonable. That is a question for a future evidentiary hearing held at a later date. I have allowed a briefing and submittal of affidavits on the issues of the scope of factors used to determine just and reasonable, and the hearing was noticed to take only argument. I want to again clarify that the deadline for uncommitted owners to respond to the application has not passed. They can still participate in future evidentiary hearings on the integration application. Witnesses and evidence may be submitted at the future evidentiary hearing. With that, I'd like to first take appearances. Mr. Christian, will you please identify yourself and who you represent for the record?
Michael Christian, here for the applicant Snake River Oil and Gas, Mr. Administrator.
Thank you. Mr. Becker, can you please identify yourself and who you represent? You don't have to stand up if you don't want to.
Gail Becker, representing Jordan Gross, Dana Gross, and Little Buddy Farms, LLC.
Thank you. Mr. Piotrowski, can you please identify yourself and who you represent?
James Piotrowski, on behalf of Joey Ishida, Brenda Ishida, Juanito Lopez, Sarah Weatherspoon, David George, Jessica Ishida Sanchez, Juan Sanchez Jr., Gary Hale, Ryan Gentry, Mark Bidlack, and Marianne Miller, as well as Citizens Allied for Integrity and Accountability.
Thank you, Mr. Piotrowski. Ms. Winters, can you please identify yourself and who you represent?
Good morning, Mr. Hearing Officer. My name is JJ Winters, Deputy Attorney General. I'm appearing on behalf of the Idaho Department of Lands.
Thank you. Are there any other uncommitted mineral interest owners in the proposed unit that plan on participating today? All right. Next, I'd like to ensure all parties understand what documents are in the record. Documents in the record, docket number CC-2023-OGR-01-001 are on the OGCC website at ogcc.idaho.gov/administrative-hearings. I also have a copy. I'm going to list the documents for the record orally. January 23rd, 2023, application for integration with exhibits A through L. January 23rd, 2023, Idaho Department of Lands, acknowledgement of application. January 30th, 23, the affidavit of publication or a notice of intent and certified mailing receipts. January 31st, 2023, the order vacating hearing and notice of hearing to determine just and reasonable factors. February 1st, 23, affidavit of publication. February 9th, 23, comments from Mary Ann Miller. February 17th, 23, Gail Becker on behalf of Jordan and Dana Gross and Little Buddy Farms LLC, notice of appearance and motion to continue. February 17th, 23, the applicant response to motion to continue. February 21st, 23, comment from Sarah Witherspoon. February 21st, 23, Gail Becker, motion to continue, reply brief. February 22nd, 23, James Piotrowski on behalf of Citizens Allied for Integrity and Accountability, Joey Ishida, Brent Ishida, Juanita Lopez, Sarah Witherspoon, David George, Jessica Ishida, Sanchez, Juan Sanchez Jr., Gary Hale, Ryan Gentry, Mark Vidlac, and Mary Ann Miller, and the brief of non-consenting owners in support of motion to continue. February 22nd, 23, the order continuing the opening brief deadline. February 24th, 23, the applicant, an email response to newly leased mineral interest owners. February 28th, 23, the Idaho Department of Lands opening brief. February 28th, 23, James Piotrowski opening brief. March 1st, 23, the applicant opening brief. March 1st, 23, the applicant, motion of applicant for order determining Kaya is not a party. March 1st, 23, Gail Becker opening brief. March 6th, 23, Gail Becker response brief and motion for disqualification. March 8th, 23, the applicant response brief. March 10th, 23, the applicant opposition to motion for disqualification. March 13th, 23, Gail Becker reply brief. March 13th, 23, the applicant reply brief. Again, all of this material is on the OGCC's website. In addition to the briefing on factors to be used to determine just and reasonable terms today, I received a March 6, 23 motion to disqualify the hearing officer filed by the Grosses. Snake River's counsel provided a written response to the motion. I did not receive any additional related motions or responses from other parties. Under IDAPA 0411011565, when a pre-hearing motion is filed, all parties seeking similar relief must join in the motion or file a similar motion within 7 days after receiving the original motion. 7 days have passed since the motion was filed. However, parties responding to the motion will have 14 days from the time of filing of the motion to last respond. Given that motion relates to whether I can act as the presiding officer over the hearing, and it was only filed on March 6th, I'll begin by offering all parties an opportunity for oral argument on that motion. This oral argument will be before our just and reasonable section of this hearing, but I'll allow everyone to speak for up to 5 minutes. Mr. Becker, since you filed the motion, I'll give your motion so you can begin if you would like. You're welcome to walk up, please.
Thank you, Your Honor. Gail Becker for Versus and Little Buddy Farm. As the hearing officer pointed out, we filed a motion for disqualification. Our concern is that the state is an interested and perhaps adverse party due to its ownership and management of public trust resource for the state of Idaho, namely the navigable Payette River, which cuts across the middle of the proposed integration unit. I've requested, pursuant to Idaho's public records request laws, copies of documents related to any lease or any sort of financial arrangement that has been entered into between the state and the applicant. Since this integration order looks to the type of arrangements that have been entered into between other integrated parties who chose to be integrated voluntarily, I think the state's lease is certainly something that could impact the determination of some of the issues that are put forward by the applicant here. So I'm still waiting for a response to my public records request. But out of an abundance of caution, we felt that it would be best to have a new hearing officer appointed in this particular situation so that the public can have confidence that the person who's deciding their case has not negotiated a financial arrangement with the applicant that potentially puts them in an adverse situation to other parties who are being compelled to be integrated in this particular unit. Again, our concern is simply public confidence in the process and ensuring that all parties have due process and that this is a completely transparent process for the citizens of the state of Idaho. Thank you.
Thank you, Mr. Becker. Mr. Christian, if you did file a response brief to this, if you would like to provide any testimony at this time, you're welcome to.
Thank you, Mr. Administrator. Briefly, I've really already pointed out in the brief that the two main points. One, our view is that the motion is untimely. It was filed beyond 14 days after you appeared on the scene as the hearing officer via your January 31st notice of hearing, and was not filed promptly following the availability of the facts upon which it relies. I'm not going to go through every detail of that, but it's in my briefing. I think it's also it's meritless on the substance. The point made in the motion itself, in the brief submitted by the Grosses, was that there is a conflict of interest because you oversee the leasing of state minerals, which isn't the case. A completely different person within the Department of Lands under a different supervisor is responsible for state leasing. So there's a division of interest, and there hasn't been any evidence provided that you have any personal animus or bias. And finally, you are not a generic hearing officer to be disqualified and replaced. The statute specifically provides that the administrator of the oil and gas program is to decide integration applications. So for those reasons, and again, as set forth in our briefing, we would request that you deny the motion for disqualification.
Thank you, Mr. Christian. Are there any other parties who would like to offer argument on this?
Mr. Thomas, I'd like to be heard on this.
Thank you, Mr. Piotrowski. Go ahead.
Thank you. In addition to the grounds set forth for disqualification in the Gross's motion, there is an even larger and more substantial basis for disqualification of the hearing officer in this case. It has nothing to do with personal animus or bias. Mr. Christian focuses on the wrong issue. What it has to do with is institutional bias. The Oil and Gas Commission, which is a part of the Department of Lands, of which you are the administrator, sir, has a compulsion, a statutory compulsion to encourage the rapid development of oil and gas resources. This is your job as a matter of Idaho law. To then have you sit as a hearing officer over the terms under which those items will be decided creates the tremendous appearance, at least the appearance and the likely actuality of institutional bias. You cannot tell us what is just and reasonable when your job is to drill, baby, drill. You cannot tell us that you have taken appropriate steps to ensure the rights of all interested parties when your statutory command is to get the hydrocarbons out. And as a result, this process is fundamentally unfair, fundamentally violates due process of the law, and fundamentally represents the wrong decision maker for this case. If the appearance of impartiality matters, then the decision maker should not be an entity who is statutorily commanded to approve integration and drilling and extraction. It should instead be a neutral third party who understands that these are merely business decisions to be made. And yet, this system, which includes a party that's that works for an interested party, isn't accomplishing that. I believe we should find a neutral hearing officer for these cases, starting with this one and going forward.
Thank you, Mr. Piotrowski. Ms. Vega, do you have any argument at this time?
Thank you, Mr. Thomas. Just a reminder, I was just observing this morning. I don't intend to participate, but maybe Ms. Winters has some comments on behalf of the Department of Lands.
Thank you, Ms. Vega. I misread the script at the bottom of the picture. I apologize. Ms. Winters, do you have any comments at this time?
Briefly, Mr. Hearing Officer, as you indicated, the Department of Lands filed an opening brief in the just and reasonable, but did not necessarily address the motion to disqualify. After reading the briefing and considering the filings, the department would just like to make a statement on the record that it is disappointed in the accusatory tone in which some of the briefing has been written. It is unfortunate that the department has to defend the integrity of the department and the Oil and Gas Commission, both of which are separate legal entities created by statute. Although the Oil and Gas Commission is housed within the Idaho Department of Lands, these matters remain separate. My client, Mr. Thumb, and I'm sure Mr. Thomas, take great care to place the required screens between them. Neither entity created the statutory arrangement, but all take it very seriously and will continue to follow the law as it is written. Mr. Thomas, with his experience in the oil and gas industry, is a preferred hearing officer for the very reason of his experience. And to imply that either the department or the state or any member of the commission is anything but fair and impartial is unfortunate. It is the department's hope that this hearing and any upcoming hearings and briefings be conducted with professionalism and respect. Thank you.
Thank you, Ms. Winters. Are there any other parties who would like to provide arguments on this? All right, Mr. Becker, you can offer any final rebuttal if you'd like.
I just want to address the timeliness here. As the hearing officer is aware, the statute contains some extremely tight timeframes here. And the statute for disqualification also does have some timeframes, but it also has a general provision regarding discovery of factors that may indicate a potential grounds for disqualification, such as those that we've indicated here. I think what's lost in Mr. Christian's arguments is the fact that the average citizen who receives this giant packet of information for an applicant to extract hydrocarbons that have sat under the earth for hundreds of thousands of years, millions of years, all of a sudden is placed on this fast track. You got to get it done right now. This is a big deal to these people who are all of a sudden forced with the prospect of staring at a drill rig for the next, or drilling operation for the next 30 years, to consider terms of leases that are in fine print and dozens of pages long. This is a lot for someone to digest. In this situation, Mr. Christensen points out dates at which his applicant did certain things. It then takes time for things to get mailed out to the parties who are being told that they're about to be integrated under terms that Mr. Christensen's clients think are fair, without providing much information for the people to be integrated to consider. In this particular case, my client went to his longtime attorney, and after dealing with that, a replacement attorney within that office, then all of a sudden was informed that in fact his longtime attorney represented Mr. Christian's client. And so that created a bit of a delay. My client then searched out another attorney who had some experience in mineral extraction underneath Idaho's ground, some experience in administrative law practice, and we were able to connect and sign an engagement letter. There's a lot to digest and consider in a short amount of time, and realizing that, hey, there's a navigable waterway that traverses this unit, and looking to the statutes and rules that then allow one to realize that the state potentially has an interest, a monetary interest, as well as a regulatory interest in this particular integration unit, I think requires a lot of connecting of the dots that frankly, the average attorney wouldn't have put together. Here, I was able to connect those dots. I did so in as quick of time as reasonably possible. I'm still waiting for actual leases or documentation as to what the financial arrangement is between the Department of Lands and Snake River Oil and Gas. I still don't have those documents because of the timeframes under the Public Records Request Act. So we have moved diligently here, and I immediately notified the hearing officer once I connected those dots here. And frankly, with all due respect to Idaho Department of Lands, I think it's something that should have been pointed out in their opening brief. Again, in the interest of full disclosure here, that they're not simply a regulatory function, but they are an interested party in this particular situation. So again, I'm not trying to be accusatory here, but you know, this is government works best when it's transparent and the people understand how their decisions are being made by the elected officials and those that are paid for with tax dollars. And so again, we're interested in transparency. We're seeking transparency through a public records request. We feel that having an independent hearing officer in this situation is going to provide that confidence that government is working for all of these people and not simply the applicant. Thank you.
Thank you, Mr. Becker. After the arguments I've heard, I am deciding not to disqualify myself as the hearing officer. On the follow, I'll just tell you this orally. The Grosses cite that the navigable waterways in the integration unit means that I am not a disinterested party. I do not supervise or administer the oil and gas mineral leases in the Department of Lands for the state. That is a different division entirely. I don't have any knowledge of what those specific lease terms are. There are no facts indicating that I have bias, prejudice, interest, or substantial prior involvement in the matter other than as a presiding officer. The request also appears to be untimely, as my employment and job titles were included on the notice of hearing issued well over 14 days before the motion, and the Grosses do not indicate what new facts were discovered later. The notice of hearing was issued January 31st, and the Grosses attorney appeared on February 17th, 23. Finally, Idaho Code 47.328, sub 3, sub D expressly provides that the administrator shall hear the application and make a decision. In the event I decided to hire a hearing officer, I'm still statutorily asked as the administrator to issue the final order, or issue the order, excuse me. While I am ruling on this motion orally now, I will follow up with a written decision stating the facts and reasons for my determination pursuant to Idaho Code 67.5252 sub 3. All right. Switching gears, let's turn to the hearing topic of the scope of factors used to determine just and reasonable. The purpose of this hearing is not to address which terms are in fact just and reasonable. That is a question for a future evidentiary hearing at a later date. I have allowed briefing and submittal of affidavits on the issues of the scope of factors used to determine just and reasonable, and the hearing was noticed to take only argument. So we'll proceed with oral arguments at this hearing as follows. I will first hear arguments from the applicant, Snake River. This will be followed by arguments from Mr. Piotrowski. This will be followed with arguments from Mr. Becker. Afterward, I will accept arguments from the Idaho Department of Lands. then other uncommitted owners, if they are present. Then Snake River will have an opportunity for rebuttal. Arguments for each party will be limited to 10 minutes. After argument is complete, I will accept public comments. I will limit these comments to 5 minutes. I'll first take public comment from those appearing in person, and then I'll take comment from anyone on Zoom. So with that, I would invite Mr. Christian to provide argument at this time.
Thank you, Mr. Administrator. You have the applicant's proposed factors for consideration. We set them forth both in the application, and I think they're listed in the briefing. As you're aware, the administrators found those factors to be appropriate in 3 previous integration proceedings. The applicant has indicated that it's not aware of any circumstances in section 24 that would make it any different from any other previous integration such that those factors should be changed or not used. Neither of the groups of objecting mineral owners have offered any evidence that section 24 is different in any way. I'm not going to spend further time repeating my briefing on that subject or your previous orders back to you. But as you previously found, the factors are within the authority of the commission. They do not impose burdens, conditions, or restrictions in excess of or inconsistent with existing statutory provisions, and they comply with commission rules. And finally, they're consistent with the purposes of the act, which is to encourage development, protect correlative rights, and prevent waste. As you've noted per your notice of hearing, the purpose of this proceeding is for the parties to propose factors to be considered in the later merits hearing in determining just and reasonable terms of integration. It is not to determine whether discovery is permitted, although the act expressly says it is not. It is not to determine whether to halt the matter entirely and refer it in some unspecified fashion to a district court. It is not to determine whether integration should be denied outright. It is not to determine whether IDAPA 200702 is in effect, although it is. It is not to consider specific terms and conditions of integration, such as royalty rate or bonding or surface use or any other specific condition. I'm going to pass over the subject of the tenor of the briefing. I think Ms. Winters addressed it well. On the substance, to the extent that they have anything to do with establishing factors to be considered, the cases that regarding rate setting by regulated public utilities that the grosses rely pretty heavily upon, and I think Mr. Piotrowski may have in the past, are not relevant. The act here is not concerned with establishing a rate of return on invested capital as the laws and regulations for regulated utilities are. It is concerned with balancing correlative rights and preventing waste, and encouraging the development of oil and gas resources in the state of Idaho while doing so. Working interest owners and committed royalty owners have entirely different interests than regulated utilities. One is interested in earning a fair but essentially guaranteed rate of return on invested capital while occupying a government-sanctioned monopoly position. The other is interested in maximizing efficient production in a non-monopoly position, while balancing the correlative rights of others. Several of our issues that are argued, particularly by Gross, are again irrelevant for the purposes of this proceeding. The statute does not permit discovery in integration proceedings. This is recognized in both the APA and the AG's rules that discovery is allowed only when permitted by the statute, and that's not the case here. There is no due process requirement of discovery in every administrative proceeding. The driver's license case, suspension case cited by the Grosses is not relevant. It does not say that discovery was required in every administrative proceeding, and it involved a scheme where issuance of subpoenas was already allowed as part of the defined due process. And this is true on a number of points, but if the Grosses think that this should be changed for integration or anybody else does, they need to take it up with the legislature. Hundreds of owners have voluntarily leased, and millions have around the country, and markets have been established without such a process, without the operator providing unfettered access to its books and records. Likewise, if the Grosses or any other party think that the rates set for deemed leased owners which, by the way, is both equal to the prevailing rate in Section 24 in the basin generally, and consistent with the rate set by statute in other states. If they think that it needs to be different, again, they need to take it up with the legislature. If they think that there is evidence that the market for lease royalty rates is different than Snake River has suggested, they can prevent that evidence at the merits hearing when it's scheduled. This is not the time and place for arguing about specific terms and conditions of integration, whether it's bonding levels or prohibition of surface use or prohibition of flaring or limitation to a single well or compensation beyond what the integration statute provides for. Those are not factors to consider, they are outcomes. The factors that the applicant has proposed for consideration already allow for a party to present evidence on those subjects and make the case for why circumstances, whatever they may be, of Section 24 or other proposed operations relative to their property calls for changed terms and conditions. Regarding the, I'll say one more thing. What the Grosses seem to argue is that the market, they argue repeatedly that Snake River wants to impose sub-market rates. But they seem to be arguing that the market is a rate and provisions that provide maximal protections to uncommitted mineral owners and a royalty that's based on externalities other than the value of the oil and gas produced. But that's not a market value. Regarding the items that are attached to the Grosses briefing, the article advocating for higher royalty rates in state leases doesn't have anything to do with royalty rates for integrated owners. It doesn't contradict the market evidence already presented by the applicant. Secondly, the lobbying information about the $250 the Idaho Petroleum Marketers Association gave to Representative Boyle's campaign is irrelevant to the selection of factors to be considered. In any case, the Petroleum Marketers Association is not the gas industry. It's a trade group that represents gas station owners. So whatever the Grosses think it might show, it doesn't. Lastly, the December 22nd, 2022 production report that I think they've attached to one of their last briefs, really in the applicant's view should be a cause for celebration. There were abnormally high prices for a very short period, and as a result, royalty owners are going to receive bigger checks and the state is going to receive more severance taxes because the applicant generated more revenue. That is the way it works. But that single report is not evidence that Snake River has done or will do anything unfair toward the owners. Lastly, the constitutional arguments that the opposing owners raise repeatedly are not issues for you to decide or that you even have the authority to decide. But I will point out that what they are arguing for is far in excess of what Judge Windmill ordered in the Kaya versus Schultz case. And I would argue that we are here because this process is already far in excess of what he ordered. He ordered only that the department specify factors before the merits hearing so the parties would know what types of evidence to bring. He specifically found that the process would not be delayed because that was all he was ordering. And that hasn't turned out to be the case. The objecting owners are receiving more process than that, several rounds of briefing, oral argument, in other words, up to 3 or 4 opportunities to be heard and to tell you what they think the factors ought to be. Of course, they are entitled to be heard. This doesn't mean that they're entitled to turn every proceeding into a full-blown lawsuit. No other state does it that way. Other states' more limited processes have been upheld against challenges for many decades. I am not going to repeat from my briefing again why the factors that the applicant has proposed are appropriate because you've already issued multiple orders under similar circumstances, and I think your reasoning in those orders is sound. So with that, I'm happy to stand for questions. Otherwise, I will speak in rebuttal.
Thank you, Mr. Christian. I reserve the right to ask questions later during your rebuttal. I don't have any questions at this time. Mr. Piotrowski, I invite you to provide any arguments you would like.
Thank you, Mr. Thomas. After just being lectured that this is not the time and place to discuss what's actually just and reasonable, Mr. Christian spent a lot of time discussing what's just and reasonable. And I wish we would have a little more consistency in the position taken by all parties to this process. Because, for instance, the purpose we are here for today is to determine what would be necessary for you, the hearing officer, to set terms that are just and reasonable. I would start that number one, is the ability to not integrate. If Snake River Oil and Gas is guaranteed integration, then this process cannot yield just and reasonable terms. If there is no option to not integrate, then we're here spinning our wheels because you're going to integrate. And that violates due process. It violates notions of fairness. And it absolutely violates the idea that the terms must be just and reasonable. Because if there are not any just and reasonable terms, you don't have the option to say, no, don't integrate. And which means you are required to assume that there are just and reasonable terms. That's a rigged process. That is not a reasonable process. It is a statutory process, I realize, but it is a rigged process. As a hearing officer under the Idaho Administrative Procedures Act, you are required to follow the law, not just the statute that sets up your position. You are required to follow the law broadly as it relates to this matter. And in this manner, it is possible that integration is not warranted at all. And yet that is not an option available to you. I would suggest either you make that an option available to you or admit that you can't set just and reasonable terms. That's number one. Two is you need to have the power to adjust the royalty rate. This is a financial transaction. Snake River Oil and Gas is in this business to make money. Period. End of sentence. Done. They are not performing a public service. They are not interested in the rights of mineral owners. They are in this to make money. And the suggestion that we will not address the royalty rate at all means that this cannot be a process for setting just and reasonable terms, because the most important just and reasonable terms in any compelled sale are what's being sold and what's being paid for. And yet you've had the ability to take a just royalty rate taken away from you. So again, Mr. Hearing Officer, either write a decision that says you can't set just and reasonable rates because your hands have been tied, or adjust the royalty rate. Find authority to adjust the royalty rate. In a prior case, you concluded that you had some power to adjust royalty rates in leases, a power you have not ever exercised, a power that we don't think exists. Because in a lease by definition is a transaction between two individuals. Now, if you can adjust private contracts, that would be an interesting outcome. Private contracts that are already executed. I don't think you can do that. Your power is to set terms for those who will be offered leases, those who will be deemed leased, and those who will have other interests. But you cannot compel people to enter into leases. You can only deem them leased. Third is you really ought to be limiting integration to the pools that are disclosed, the pools of hydrocarbons that are disclosed by the application. You can't possibly know what are just and reasonable terms if we're talking about a pool in sand B, but you also integrate the interest in a pool in sand D, which is totally separate, may not even exist. If it does exist, we don't know about it. We don't know its size. We don't know its value. So on the third or fourth thing, depending on how you count these, that you ought to do is ensure that integration is limited to what we absolutely know about today. Integrating unknown interests would be literally impossible to set just and reasonable terms. If there is, I don't know, 50,000 feet deep, there is a massive pool of crude oil. Well, the terms for that lease, the terms for that integration would be vastly different from the terms of a small pool of natural gas at 5,000 feet. To accomplish this, you should require full disclosure by both the Department of Lands and Snake River Oil and Gas of all information in their possession that would be likely to be relevant here. That would include the extent of the pool, the likelihood of recovery, forecasts or predictions of market rates in the future. While you can call this discovery, you could also just call it the hearing officer exercising his authority to ensure that the proceeding is fair and reasonable by ordering Snake River Oil and Gas to disclose all of that information. Let's not call it discovery, since Mr. Christian is going to repeatedly tell us there is no discovery allowed. Let's call it compelled disclosure. Next, you should consider all possible methods of extraction and drilling. The fact is that what happens in these cases, as the hearing officer well knows, is that integration is granted and then a well permit is submitted, and the opportunity for real public input in the well permit process is extremely limited. And yet, that is precisely where the rubber meets the road. Rather than relying on a less open, less public process that is not accompanied by due process, let's discuss methods of drilling and extraction here and now in this proceeding and set those terms as part of the integration order. Another factor you must address is preventing the confiscatory taking and protecting property owners from the bad business decisions of their neighbors. The legal fiction that this is fundamentally some kind of a democratic process is just that, a fiction. Once 55% of people have leased, everybody else is stuck. There is no other method, there's no other process that I'm aware of in the American economy where I am stuck buying into the bad business decisions of my next door neighbor. Yes, the actions of a neighbor can affect property values on the margins, but if my neighbor sells his $500,000 house for $100,000, I cannot be compelled to sell my similar house for $100,000. And if I were, that would be neither just nor reasonable. Next is, I think the hearing officer really ought to address finding and appointing a neutral decision maker. Idaho law is very clear that where a decision maker has some interest, has the appearance of impropriety, not the reality, even just the appearance, that decision maker should step aside. Yes, there is a statutory requirement that the administrator do this. That has not stopped the Idaho Supreme Court from ordering disqualification in similar cases. Now, I'm not re-arguing the disqualification motion. What I am suggesting is that one of the factors for ensuring that terms are just and reasonable is that the decision should be made by somebody who is not employed by any division of any property owner. Mr. Thomas, no offense to you, but the fact is you are employed by a property owner in this case. And in terms of setting just and reasonable factors, one of the things you could do is say that the remaining proceedings will be conducted before a true neutral. Finally, I want to respond to something that Mr. Christian said. This process that we're following is not the result of the decision in Kaya v. Schultz. Kaya v. Schultz did, in that case, the federal judge did what federal judges do. He decided a narrow issue and declined to decide any other issue. The narrow issue he decided was that in the absence of prior disclosure of what just and reasonable means, it violated due process to issue a decision in that case. That's all he decided. He didn't decide anything else. He didn't decide that the process was otherwise constitutional. What he decided was the process was unconstitutional for this reason. Everything after that comes from your bosses, the Oil and Gas Commission. The Oil and Gas Commission charged you with determining in each case what were the factors that would be considered in that case. And when Mr. Christian suggests that you should stop doing that and just keep using the same factors in every case, he is asking that you violate the command given to you by your employer. I would suggest, after nearly 30 years as an employment lawyer, that you decline that invitation. What we need here is a process where it is possible to decide against integration. It is possible to adjust the royalty rate based on the individual factors that might make a different royalty rate more just, more reasonable. You should be able to adjust the bonus payment again so that you can determine whether those factors require something different. You should limit integration. And in the process of doing this, it is going to be necessary to require full disclosure of all the information the parties have. If Snake River Oil and Gas, for instance, is aware that there is not one pool of hydrocarbons, but two, and they don't, or 3 or 4, and they don't disclose that to objecting owners, non-consenting owners, then we are fundamentally engaging in dishonesty, injustice, and unreasonable. If you then integrate all of that interest. The fact is that the statute here does not allow you to do what the statute tells you to do to determine what is just and reasonable. And so it is well past time for somebody to simply admit that you can't set just and reasonable terms if you can't change the price. This is an economic financial transaction, among other things. And if you can't change the price, you can't be just and reasonable. Thank you very much.
Thank you, Mr. Piotrowski. I do have 1 or 2 questions for you, if you don't mind.
Absolutely.
First one, just for clarity, Snake River Oil and Gas and the department have proposed using the same factors used in the past 3 integrations, specifically docket number CC-2022-OGR-01-001, 002, and docket number 2021-OGR-01-02. Do you agree with these factors? And if not, what's your alternative proposal?
My alternative proposal is set out in the brief. Those factors were inappropriate in those cases. They are even more inappropriate in this case. Exactly how and to what extent they're inappropriate, we don't know, because Snake River Oil and Gas is permitted by your agency to not disclose what it knows about my client's property.
Thank you, Mr. Piotrowski. One more question. Are the 11 property owners mentioned in your brief members of Kaya?
To my knowledge, they are.
Okay. Do you have additional clients in this unit that are also Kaya members?
I don't know that. I mean, I don't have additional clients in this unit. I don't, I can tell you that. I don't know whether Kaya has additional members in this unit.
Thank you, Mr. Piotrowski. Those are all the questions I have at this time. All right, Mr. Becker.
Gail Becker, again, on behalf of the group with Little Woody Farm LLC. I want to correct something that Mr. Christian said. This is a state-sanctioned monopoly. There's one applicant. There's no one else here who's applying to integrate this property. There's no other operator in the entire basin here who's taking the oil and gas from underneath these people's property. So this is a take it or leave it deal by one applicant. And we're being told to go to the legislature and change the law. Unfortunately, it seems like Snake River Oil and Gas, an out-of-state company, has a closer relationship with the legislators than my clients do, than the constituents that they represent do. This impacts surface owners in the state of Idaho who vote for their representatives. Snake River Oil and Gas can't vote. Its board of directors, its corporate headquarters aren't in Idaho. The money they make gets sent out of Idaho, and we're left with the mess to clean up afterwards. There was a promise that this was going to be a boon for small towns in Idaho, in the Payette, Weiser River area. What have they got? Sub-market royalties, the risk of having to clean up a mess whenever this company leaves. They want something better. My clients are not opposed to oil and gas leasing. They're not opposed to oil and gas integration. They want to be treated fairly, with dignity, and with respect. And I think that's for everyone in this basin who's now faced with the process of being forced to sell their oil and gas underneath their property to one applicant here. We're being told that this is a wildcat operation. It's highly risky. $9 million a month. I don't know if anyone else in this room is making $9 million a month. I certainly am not, but $9 million a month is a good chunk of change. And how much of that is staying in Idaho? We don't know. We don't know because the applicant won't tell us. We have a statute that their industry wrote that they believe doesn't allow us to even find out. We don't know what their corporate structure is, how they're using wholly owned subsidiaries or closely related entities to do business like a shell game and inflate the amount of their overhead so that people's royalties are artificially deflated. Not only is 1/8 a lowball number. It's 1/8 of what? How do we even know what 1/8 is? If you're gonna take garbage in and put garbage out, that's what this process is here. And so, yes, I understand the department's put between a rock and a hard place. It didn't write this statute. Legislators did with the behest of the oil and gas industry. And so we're stuck with it. And I believe it's wholly unconstitutional. And a factor that this hearing officer said that would be considered is an administrative order cannot violate constitution or statutory provisions. Well, this entire statutory scheme violates the state constitution, the federal constitution. And we've already had one court case take a bite out of a denial of due process, and perhaps we may need another one here to set this case back, this type of proceeding back on the tracks. The concerns in this particular situation are, yes, right out of the gate, there's a denial of a right to discovery. So the applicant doesn't tell us who works for it, doesn't tell us how much money it's making, doesn't tell us what its costs are. And we're just supposed to come in and propose fair and reasonable factors in the dark. Yet the statute has an opportunity for this hearing officer to put it back on the tracks. Idaho Code 47320 requires that the integration order proposed be on terms that are just and reasonable. Just is what's morally right. Is it morally right for this out-of-state company to come in here and drill baby drill in people's yards? They got to sit and look. They had a view of the hills, the farms, and now all of a sudden they got a flare in there that they're looking at. Well, the applicant itself says, well, the price of that is whatever royalties they pay. Well, again, back on Mr. Piotrowski, just because someone else signed on to a bad deal doesn't mean everyone else has to get a bad deal. The price that's paid needs to reflect market realities here. Yes, Snake River is absolutely entitled to make a reasonable rate of return on its investment. I don't doubt they spent a ton of money going out there, thumping around, looking for what kind of gas is located where. But at some point, this is no longer a wildcat in operation. They're here to stay and they're here to make a ton of money. And the less they leave in Idaho, the better for their out-of-state company profits. So tell us how much you're making, show us the records, let us understand exactly how much money is going out of state and how the wholly owned subsidiaries and related entities are being controlled and how much they're making. Let the citizens of Idaho know if they are being treated reasonably. Because not only does the integration order need to be just, morally right, it needs to be reasonable. Reasonable, I've pointed out, it looks to the reasonable rate of return, the investment back expectations. Snake River Oil and Gas has that. My clients have that. Other people who might be integrated down the road have that type of expectation as well, that they're treated reasonably, that they're not forced to sell their house for sub-market rates, that they're not forced to go clean up a drill rig that's been left there after some company decides to go bankrupt and forfeit its, what is it, $16,000 or $6,000 statutory bond. That's not reasonable. 30 years from now, $16,000 is probably going to buy a loaf of bread. We need to have fair and reasonable rates and bonds that prepare for the eventuality that a mineral and gas extraction company cleans up its mess when it's done. Now, I understand the hearing officer's hands are tied with a statute that's unconstitutional that prohibits discovery. However, the hearing officer is empowered to issue subpoenas. It is empowered to issue orders to ensure that the terms are just and reasonable. And so what I would propose is that a briefing deadline be set to require a list of documents and areas of inquiry that we think need to be disclosed. And then the hearing officer can decide based on that, what information it will compel the applicant to disclose to the objecting parties with sufficient time that they can hire their own expert witnesses, they can hire their own accountants to go through and propose what is actually a just and reasonable term. I also think that the terms of the lease right now are proposed on a take it or leave it basis. Again, Snake River Oil and Gas is working with the legislature right now to make it even a more take it or leave it deal. And if that goes through while these proceedings are in place, that statute, I think, will also be challenged because it's even more unconstitutional than one we're already working with here. But those are the factors I think we need to consider here. Are the citizens of the state of Idaho getting a good deal? And right now, we just don't know. We know Snake River Oil and Gas is making a ton of money, and they're proposing 4 to 5 new wells in this area. This is not a wildcat play anymore. They are here to make money, and they want to do it as cheaply as they possibly can. It's time to put this train back on the tracks and make sure that the citizens of Idaho are actually making out all right as they were promised whenever the first gas was discovered here. Thank you.
Thank you, Mr. Becker. I've got a few questions for you.
Yes.
First, you just mentioned earlier in your argument, $9 million a month. Can you tell me exactly what you're referring to there and what your source was?
Mr. Christian cited the department's website that had their production reports. I looked at the latest one that was filed, which was December, and it showed $9 million. I think if you added up the numbers on, I believe it was the last 3 of 20 pages, they go well by well. Some information is redacted. We don't know why, but the final report there showed $9 million approximately. And so, that looks to be in the, $110 million a year range. I didn't hear any rebuttal from Mr. Christian taking issue with that number. So it sounds like it's accurate. That sounds like that's the value of the gas that they sold, but how that's then split out with costs of production and overhead and other things that they take out before they pay royalties. And frankly, the total amount of royalties that stay here in the state of Idaho, we don't know. I don't even know how much the Department of Lands is getting right now under the terms of the lease that it entered into. So, we hope to flush all that out and make sure that that people are being treated justly and reasonably.
Thank you, Mr. Becker. One more question. In the opening brief, you shared some items that could be seen as factors or terms. And you just spoke to that a little bit already, but for clarity, can you please tell me which of these are actual factors versus terms that you would request at the evidentiary hearing?
I'm looking back through my brief here. What I'm saying is that I think the terms that the hearing officer has used in the past, the 8 terms that have been cited in Mr. Christian's briefing and in prior orders are certainly things to consider, but I worry that they are being used to arbitrarily narrow issues and that they should be viewed as more expansive. Specifically, just and reasonable, that is not statutorily limited. It is a broad and open-ended inquiry that really places this hearing officer sitting as a court of equity over a state-sanctioned monopoly. So what I would propose is that things that to be considered are overall, are things just and reasonable? And the starting point of that is who's making what and where's the money going? And so, can that fit within these eight factors? Arguably, I would say overall, we've got the requirement that the statute must be interpreted consistent with Idaho's Constitution and with the federal Constitution. So, once we have information, perhaps additional factors come to light. But right now, simply saying, well, we got these 8 factors that we've used in the past, I don't even know what we're here arguing about yet, because I can't get any information out of the applicant here other than what it voluntarily chooses to provide, which is self-serving statements that say, in my experience, these things aren't reasonable. Well, to any lawyer who's been in a court, the reasonable what is reasonable in terms of relevant discovery is things that could lead to the discovery of relevant information at trial. Mr. Christian's clients is already saying, yeah, this isn't relevant, you don't need to consider it. So I'm saying at the outset here, let's take a step back, let's require some additional financial disclosures, and then maybe we need to revisit these terms here. But off the bat is, are the citizens of Idaho being treated justly and reasonably? That ought to be condition number one.
Thank you, Mr. Becker. Are there any other uncommitted mineral interest owners in the spacing unit who would like to provide argument today? All right, thank you. At this time, I'll invite the Department of Lands to provide argument. Ms. Winters.
Thank you, Mr. Hearing Officer. Beyond what the department provided in its briefing regarding just and reasonable factors, the department has nothing to add.
Thank you, Ms. Winters. I'll allow Snake River to offer your rebuttal at this time.
Thank you, Mr. Administrator. Speaking first to Mr. Piotrowski's points, the assertion that integration is guaranteed, of course, ignores the fact that we can't even get to where we are today without having engaged in a lengthy resume of efforts and having achieved voluntary leases with a significant majority of the mineral owners in the section. And beyond that, we have to show, as part of our application that we had an adequate resume of efforts to attempt in good faith to lease those uncommitted owners who are now subject to integration. We have to show that we've complied with fairly extensive notice requirements and all the other requirements of the statute for an integration application. So it is not accurate to say that integration is guaranteed. There's a significant amount of effort and clearing of bars that occurs before we even get to this point. With respect to the argument about the ability to adjust royalty, I mean, this exists. Mr. Piotrowski acknowledges the statute says for the option under the statute to elect to lease, the royalty is set at a minimum of 1/8. The objecting mineral owners are perfectly within their rights to come to the merits hearing and provide evidence that the royalty rate for the lease election should be higher. For example, because they think that the fair market royalty rate in the area is no longer 1/8, it's something different. The deemed lease rate of 1/8 is set in statute as it is in many other states with integration or compulsory pooling statutes. And of course, there's reasons for that. That this all goes back to the purposes for spacing and integration, which is to deal with the effects of the adverse effects of the rule of capture. And the incentives in the statute are not to incentivize mineral interest owners to hold out for the best deal possible via integration. Otherwise, no development would ever occur because everyone would hold out. There is a balancing again going on of the correlative rights between those mineral interest owners who have committed to development through leasing and the operator. And again, we don't get there until a significant majority of people in the unit have made the decisions that they want to develop. There's a balancing of those interests and the interest of those uncommitted owners. The purpose of the proceeding is not to maximize the return to one side or the other. To Mr. Piotrowski's point that you haven't exercised the authority to adjust the lease rate in prior proceedings is because there hasn't been any evidence offered to you to do so. The evidence that's been offered has consistently been, what the market royalty rates for leases in the area has been for some time. we hope that we have greater success and that more operators come in. And if more operators come in, there will be greater competition, and royalty rates and bonuses will undoubtedly rise faster than they have. They have risen since Snake River got here. Apparently, just not fast enough, for the purposes of the grosses and the other uncommitted mineral interest owners. To me, it's Mr. Piotrowski's point about, limiting integration. The fact of the matter is, if you look at the application here, Snake River has in fact identified multiple sands that it wishes to test down to its planned total depth of its planned initial well. So there is already information in the application, indicating what it is that Snake River wishes to develop. And what it wishes to integrate. To his argument about disclosure of all possible methods of extraction, again, the operator has to submit a application for permits to drill. There are opportunities for the public to provide comment on those. There are extensive regulations that in IDAPA 2007-02 that the operator has to comply with technically to ensure that the wells are operated safely and efficiently. If participants in the process think that the process should be different, then they need to take it up with the legislature. With respect to Mr. Piotrowski's argument about changing the hearing officer, of course, that would directly violate the act. As you already noted, you're required to make the decision in this case, even if you hire or appoint a hearing officer, they would issue a recommended decision, and you're required to make the ultimate or issue the order finally. So a term or condition that exceeds or violates the terms of the act is by definition unreasonable. And lastly, to Mr. Piotrowski's point that I have mischaracterized what Kaya versus Schultz, what Judge Binmo ordered in that case, I quoted his language in my briefing. That's exactly what he ordered. There is the opportunity for mineral interest owners to provide evidence, additional evidence, and there has been in every previous integration proceeding to provide evidence to support terms and conditions that they think should be different from what the applicant proposes. That remains true in this case. Objecting mineral interest owners will have the opportunity to present evidence to apply the factors. And if they choose not to do so, that's their option. And I guess to Mr. Piotrowski's argument that our suggestion is not simply that we should just use the same factors every single time. We haven't come in here and suggested that to you. We in our application provided you with reasons why those factors were, if they were appropriate before, are appropriate now. And we know of no different circumstances in Section 24 that should compel you to use different factors for consideration. And again, if the objecting mineral owners wanted to present evidence to you of circumstances in Section 24 that would compel the use of different factors, they were welcome to do here today, and they didn't. Moving on to Mr. Becker's comments. Honestly, his argument sounded more like a political stump speech than a legal argument. The applicant does not occupy a monopoly position. There's nothing that prevents any other operator from coming into this state and investing the capital and competing against it, and working to develop oil and gas resources and compete for leases and do all those things. We are the integration proceeding is again a balancing of the correlative rights of committed mineral interest owners and uncommitted mineral interest owners, because of spacing requirements that have come about here as well as virtually everywhere else in the producing world to deal with and mitigate the effects of the rule of capture It's not possible to develop without having some system in place that allows development to go forward if a majority of the mineral interest owners have made the decision that it should happen. So that we're not in a monopolist position. I'm not going to respond to all of the things about sub-royalty rates and cleaning up a mess and shell games and things, other than to say that it's just evidence free. There's been no evidence supplied to you to support any of those things. And that's unfortunate. Lastly, Mr. Becker said that the Grosses are not against oil and gas development or integration, and they simply wish to be treated fairly. And that's precisely what the applicant is proposing, and what the statute, frankly, provides for. They are to receive a bonus equal to the highest bonus paid in the unit prior to the application. So they're getting the best deal on the bonus side that's out there in this unit. They are because historically the lease rate has been set at the market level, they're going to get a royalty rate that is, equivalent to what other landowners who are negotiating and signing leases voluntarily are getting. That's not unfair. Mr. Becker and Mr. Piotrowski repeat that just because somebody else, agrees to a bad deal doesn't mean we should be subject to it. But there's no evidence that that's a bad deal. Under the circumstances in Idaho right now. Again, if the objecting mineral owners wish to ask for and propose different royalty rates or other terms and conditions, they are welcome to bring evidence to the hearing to support that proposal. That's all I have, and I'm happy to answer your questions.
Thank you, Mr. Christopher. I don't have any questions for you at this time.
Thank you.
I would like to move on to any public comments for those folks who have shown up in person, and there's no one to provide comments, I think, via Zoom. So if there's anyone in the room who'd like provide public comment at this time, please walk up.
I have to walk up?
Well, you can
I
talk.
can talk real loud.
Just state your name for me, please.
Dick and Sue Elzikar, we're in this district on Elmore. How long is this oil company's track record with your department? And how many years experience do you have dealing with them? Can you answer that for me?
Certainly, that's fine. This current operator acquired operations, I think, in early 2021. We've been dealing with them since that time. I've been in my role for a little over 5.5 years. And so I hope that answers your question.
I mean, and so if there's disapproval with them, you would have record of that, and you're keeping all that in record.
Yeah, the website has
Okay.
all the comments and stuff that's been provided. Thank you. Are there any other comments? Go ahead.
I'm gonna stand here because it's.
You can
easier.
even sit if you'd like.
Okay, thank you.
Wait, Joanne, just a moment. Can everybody hear
Can you
Joanne?
hear
She's
me?
talking. Okay, go ahead.
Okay,
And I'm sorry, for the record, say your name. We all kind of know you, but I want everybody to know you.
my name is Joanne Higby.
Thank you.
I own property in section 13 and 14. So I guess my only comment is when I read Ms. Winter's Department of Lands statement, number C said that the royalty should be similar to those in the section or those nearby. Did I understand that correctly? Because I'd like to know the mechanism you have for acquiring that information on nearby sections to make sure it is correct.
All right, thank you for that comment. We're not going to, this isn't a Q&A back and forth with the party, so I hope you know that she's not going to provide an answer to that, but that was a fine comment.
Okay, well, if there is not, if the department doesn't have a database or a mechanism in place, it would seem appropriate that they create one so that if there is a higher royalty paid in a nearby section, that you adjust offers accordingly.
I appreciate that. Thank you. Are there any other comments at this time?
I will.
Go ahead.
My husband and I just bought our property out on
And your name, please?
Lori Bryan's.
Thank
My
you.
husband Kevin and I just bought our property out on Northwest Fourth this last July. And so it appears in the letters, I have no background understanding of how all this oil leasing works, but it appears from what we've got in the letters that to drill, they need 160-acre portion of land. Is that correct? Is that why we're all being integrated forcibly or willingly into a 160-acre unit? I'll go on with my comments. I might be wrong. I might not be, since it's not a back and forth. That just seems, I could care less about the money and the royalties and trying to get more. It's this being forced into 160-acre unit so that they're able to drill these gas wells. We're right bordering the parcel that it would happen on, and to have to look out at these gas wells, not knowing how close they're going to be to our property line, how many of them they're going to be on that parcel next to us. It does not seem right that you could force property owners into a situation like this where they have no choice, and you're amassing this 160-acre parcel so that the drilling can happen, whether somebody wants to be a part of that or not. I could see if everybody was willing to pool their property together to do this thing, that's one thing. But when you have property owners who aren't wanting to do that, then it just really seems fair and unjust to me that would happen, and it will negatively affect the value of our property.
Thank you. I can share that for gas in Idaho, standard spacing is 160 acre to 640 acre unit. There are options if the geology presents itself to custom size a unit depending on the size, the estimated size of the pool that will be drained. So if the pool is, for example, covers 300 acres, okay, then that unit is still going to be square, right? Or geographically, but it's going to have to be obviously over 300 acres so that it could fully cover all of that pool. So that's a little bit of information I can provide, right? I can't ask these folks to testify back to you, but I'm happy to provide some questions or answers to your questions. So that is also in statute 160 or 640.
It seems like maybe that original amount, the thought would have been that somebody, the person wanting to enter into the lease would have had a piece of property that large. And so then if they did, it's really not affecting the other landowners around them if they had that 160 acre or 640 acres. But when they have a smaller acreage and then you're trying to get all the other smaller acreages around them to make up this amount, then I think it's kind of defeating the purpose or whatever of keeping those wells away from the property owners who have no interest in that. We don't want to look at them, who don't want that noise and activity right next to them to see the flames. We could see a flame from where we are already. But
Thank you. Thank you
okay,
very
thank
much.
you. Appreciate it.
Are there any other comments today?
I would like to ask a question. I'm Murray Scott. I'm representing Mary Ann Miller. The 160 acre parcels that they're drilling in. If you are the property owner of the property that is designated, do you have the absolute right to say, no, you cannot drill on my property? Do you have, is there an option on that at all? And can that parcel, that 160 acres that we're talking about, could it be into one corner and then you frack over to the area that you're dealing in? Are those things that are possible, or I haven't heard anything of the possibilities of where the locations of anything would be and how it would affect the property owners in the area. I'm just asking a question.
Yeah, I can give you a little bit of information on that. To my knowledge, and I, as was previously asked, I know what the operator's done so far. There hasn't been any unagreed between a surface owner and the operator to drill, to put a well pad on. They have a voluntary surface use agreement with the surface owners where all of the pads are. So there's the information I have for you there. And in some orders that I've given, that's a requirement, that there has to be a voluntary agreement between the surface use, right? We also have guidelines in statute that put setbacks from the unit boundary to the well, right? So that it's ideally impossible, if not very difficult, to get real close to that unit and then take any hydrocarbons from outside the unit as you're referring to. Also regarding fracturing, so far in Western Idaho, there hasn't been any hydraulic fracturing. And as a geologist, I could say that would be highly unlikely because of the way the geology is here and the formation. It's not conducive to hydraulic fracturing. You basically get a well bore full of beach sand, probably. That's a little bit of an exaggeration, but there's no real need to fracture sandstone with the porosity that we have here in Southwest Idaho. So there's just not, the geology in this area is not conducive to it. In fact, it would be probably deleterious. All right, thank you. Any other comments?
Can I ask a question?
Okay,
So then you were talking about setback, which is there a distance from one property owner to the next that they must keep their wells away from? Say our little 1.5 acre piece and the property around us that's going to be drilled on or that they want to drill on. Do they have to stay back a certain distance from our property line, or they can come right up to the property line and put in a well?
off the top of my head, I don't have that answer. I apologize. I'll find it and respond to you separately outside of this hearing, if you don't mind, to answer that. All right. If that's okay.
Yeah.
All right.
Yeah.
All right.
Mr.
What?
Administrator,
Go
Mr.
ahead.
Administrator, might I offer some information to answer some of the folks' questions briefly on behalf of the applicant?
Well, keep it very focused, Mr. Christian.
Yes, I think it was Mr. Eldecourt or Ms. Eldecourt. The question was the track record of the applicant. I just wanted to let you know that one of the principals, Richard Brown, lives in Idaho full-time. His family has connections to Idaho, go back to the 50s, and I believe they've owned a place in Idaho since the 1970s. This is a 640-acre unit, not a 160-acre unit. And it is a requirement of the statute that the drill site be leased. So we can't drill, have a drill location on an integrated tract. That's all.
Thank you, Mr. Christian. All right, it's now 10:27 on March 14th, 2023, and this hearing is concluded. I'll take this under advisement and issue a written order. Thank you, everyone, for your participation today. Oh, it'll be within 30 days. My apologies, which is April 13th. Good day.